Welcome to the Small Business Contracts Coach.
Welcome back to the Small Business Contracts Coach with attorney Darryl Shaper of the Fixed Fee Law Firm. Darryl works with Texas entrepreneurs and small business owners to draft and review contracts in plain English with clear pricing and no surprises. I'm Lisa Mosbey, your host, and today we're talking about operating agreements in Texas and what provisions matter most when business partners don't see eye to eye. Welcome, Darryl. Thank you so much for joining me today.
Thank you. Great to see you.
Always a pleasure. Darryl, what is the real purpose of an operating agreement beyond simply forming the LLC?
All right. So this is literally one of my favorite kind of documents to work on and one of the most important documents for a limited liability company. So let's briefly back up. First thing is you're starting a new company, a new business. One of the most important things you can do to protect yourself is form a limited liability company or LLC. That LLC can be owned solely by you, but once you form that, create a separate bank account for it and don't commingle your personal and company assets or expenses. You're now protecting all your own personal assets, your home, your retirement savings, everything is protected from liability if that that LLC gets in a lawsuit. So that's super important. Now, the operating agreement is the governing document of a limited liability company. It's the core founding document that sets the terms and conditions of how that company is going to run. For a corporation, the equivalent document is typically called the bylaws. But for an LLC, they call that document the operating agreement. And so all the owners and members of the company at the beginning of the LLC must sign and agree to that operating agreement. And that sets the terms of how they're going to work together, sets the ownership percentages, sets a whole bunch of important rules around how that company is going to operate going forward.
I have to tell you, I've seen so many of these operating agreements where folks just use boilerplate. They don't make any changes. They don't adapt it to their own company. When you review an operating agreement, what sections tell you right away whether it's thoughtfully drafted or just a generic template?
It is probably the first thing I'm going to look at is how are deadlocks and dispute resolution dealt with in the document. Because if you're honest with yourself, and what I tell my clients all the time, they go into initially forming a company with their friends or whoever it is, and they're super optimistic and they have the rose-colored glasses on. But the reality is that over 10 years or the life of the business, it's more likely than not that you're going to have conflict with your co-founders. That's just the reality of life. And so when you get to that conflict, you want to think about how you're going to resolve that up front rather than trying to wing it when you're already mad at each other. So that's the first things I look for that tell me whether it's thoughtfully drafted or just a form.
I bet decision-making is one of those things that you often look at as well. I know that decision-making authority can become a problem really quickly. How should voting rights and control be structured to avoid gridlock in those cases?
Well, again, as I said, think about deadlocks up front. So a couple of things that I recommend. Let's say it's a 50-50. I did a 50-50 earlier this week, LLC operating agreement. Now, let me just say up front, I told the two partners, I strongly recommend against this. This is not a good idea to go in 50-50. And they were like, well, we want to do it anyway. Then, if they want that, then we put in some deadlock provisions. So a couple of things that we have in there are, first we're going to agree to try to resolve it over 10 days. If we can't get to that, we're going to go to a mediator to try to help us. If the mediator after another 10 days can't get it resolved, we'll go to binding arbitration. Or you could pre-pick somebody that both of you trust. that could be the mediator arbitrator to decide if you can't agree. Or maybe there's an investor in the company that could do that. But having it set up 50-50, you're going to have deadlocks most likely.
Interesting. In a two-person company with equal ownership, what mechanisms can help resolve the deadlock if the pattern disagrees? I think you kind of answered it with the things that you were sharing already. Are there other things that you want to add?
Yeah, there is. The one other one that's really quite important is thinking about a buyout that already has a preset valuation on the company. So if you have partner A and partner B and they reach deadlock about something really fundamental to the business, like let's say they need to put in another chunk of money, another $100,000 each, and one person doesn't want to do that. And so at that point, that's very fair, right? For them to not do that. But you might want to say, okay, well, if you don't want to contribute any more funds, then I'm able to buy you out at a valuation that's preset as a multiple of revenue or EBITDA or something like that. So you also don't have to fight about the valuation. So let's say this little company is quite small still, and it's got $200,000 of revenue and $20,000 a year of profit, and the buyout price is set at 50% of trailing 12 months revenue. Well, you could buy the person out for 50% of trailing 12 months revenue. So then that dispute is resolved and people can move on and feel like it was a fair resolution of the dispute without litigation or without paying lawyers a bunch of money, which I don't believe in. I believe when you get in a dispute, almost always the only winner is the lawyer. And, I'm a lawyer saying that, but it's so expensive to get into a dispute. I really try to avoid them at all costs and pre-wire a solution that works.
I have to say, Darryl, some of the best business advice I ever heard was know your exit before you start your business. Like pick your partners first, then pick your business, and then know your exit. Where are you headed? What are you doing with this? What should an operating agreement say about how members exit? Or is it just bought out?
Yeah, really, it can limited liability companies and small companies in general are highly illiquid. It's very difficult to sell your interest in a small company. And so the most likely buyer is the other owners of the business. So usually you're not allowed to sell without their permission. Usually you're not allowed to sell unless you offer them a right of first refusal at whatever price you think you want to sell for before. And as we talked about before, it's much better to set that valuation methodology up front rather than setting it after the fact. So, those are key elements to think about.
The other one that comes to mind is how should the agreement address what happens if one partner stops contributing time or effort to the business?
This is extraordinarily common, and this is one of the elements that I caution people about getting into 50-50 or not thinking about this one as well. And so the two kind of concepts that I think about is either people vest over time into their ownership if there are a bunch of different owners so that over 3 years or 2 years or 5 years, they vest into their ownership. The most common vesting methodology is 4 years. With the first year, you have to get all the way through the first year before you earn any equity. And then after that, monthly or quarterly until the 4-year mark to earn all your equity. Or you can have a clawback that says, yeah, you own 50% of the company today, but if you don't contribute for 5 years, at least 40 hours a week of work to the business, then we can claw back 10% for each year you don't work full time at the business. We can claw back 10% of your ownership, something to that effect. And the only thing I'd say is you need to think through the tax implications of that. because typically that can have tax implications. If you have a vesting or a clawback, you may need to do an 83B, talk to an accountant, and make sure you've got that done properly.
So we can address any of these questions I throw at you up front in those operating agreements or the company documents. How about profit distributions? They can create tension. What language helps clarify when and how owners get paid?
Lisa, you're right on. The other key hot button issue is distributions. So now let's just say our business is $1 million a year and it's really doing great and it's making $200,000 a year of profit. Well, as one of the 50% owners, you may want half that money given to you.
Half.
But I don't know how much you know this, but high growth businesses consume cash really quickly. They need additional working capital as they grow. And so you may not be able to distribute that cash. And so this can quickly lead to conflict between the partners. One partner may be like, why didn't I get my $100,000 of profit out? But the business may have needed that. So the debate becomes, what are available funds for distribution or not available funds? So that's where people can get into a fight. The key, and then the other thing that's there is you have to pay taxes on that $100,000, even if there's no distribution. You as an LLC owner, it comes through straight to your personal income as $100,000 of income. Let's say you pay 30% tax, you got to pay $30,000 out of your own pocket, and you didn't even see the money. So the key thing that I generally require is, if there are enough funds, you must make tax distributions each year to cover the estimated taxes of the owners. That way, a richer owner can't starve out a poorer owner by never making distributions, never agreeing to distributions. And usually it has to be unanimous to make distributions. So frequently that's a situation where a rich partner could starve out the poor partner and then buy them out at a discount because they can't afford to keep paying taxes on something like that. So that's super duper important. And it's one of the things I talk extensively with my clients about.
Joe, we have a little time left. I'm wondering if you can share an example of a situation where an unclear operating agreement or the terms of that agreement led to conflict between partners and how a stronger drafting would have made a difference.
Well, gosh, there's so many. As I mentioned,
I know.
that it's going to happen most of the time. So if you have a clear and unambiguous dispute resolution mechanism like that, we're going to negotiate in good faith, then we're going to go to mediation, then we're going to go to arbitration. To me, that's a much better mechanism than the court system, which is slow, costly, and just frustrating, frankly. So that's number one. And then number two thing is, it's really often around money. That's the biggest area where you need to think through. But there are so many ways that people can get crosswise with each other. One person's not working hard enough. They're not doing a good job. And it frankly can be no one's fault. People's lives change. They have health issues. They have all kinds of things that happen in their lives. A child is born, whatever it is, and circumstances change where things may not align between the various owners of the company. So it's difficult to predict what those problems are going to be, but you should think forward to, how are we going to resolve deadlocks and disputes ahead of time, because they're more likely to happen than not.
And I think using an attorney who's versed in this, experienced in this, has had many clients, it helps because they know the questions to ask. Like you said, we don't know what's coming. We don't know if there's children in the future or a divorce situation. And having somebody who's been there through so many of these things that can occur helps us to document and be prepared for when it happens in our business. For someone who downloaded a free operating agreement template when they formed their LLC, what are the first areas worth revisiting now that the business has grown?
Well, one thing I want to say is, first of all, I recommended you form a limited liability company in any situation, even if it's a sole owner, sole proprietorship, right? You should still have that LLC because a sole proprietorship under your personal name exposes your personal assets. And if it is a sole LLC, there are a couple of great things that happen there. Number one, who cares what the operating agreement is? You're the owner. You don't have anybody until you have other people that own part of the business. An operating agreement can be downloaded and can be super simple because you control everything. So it doesn't matter at all if it's sole. Second advantage of a sole-owned LLC is it's ignored for tax purposes. You don't have to file a separate tax filing for that LLC. It just carries through right onto your personal tax form. So, but once you've got an operating agreement in place and you do have partners, they're extraordinarily difficult to change. Frequently, it requires unanimous consent of all owners to change the operating agreement. And so thinking about that can be important too. But you don't want to have one that you think is really crummy and then try to fix it later when the business is successful. If you have multiple partners, get something pretty good up front. You can always amend and restate it and make it better, but you want to deal with the topics we've talked about today up front in a multi-member LLC.
Thank you, Darryl. It's always a pleasure. As I said when we begin this, I learn so much every time I have a chat with you. So thank you.
I enjoyed it as well, and I hope we helped some of those people that are thinking about starting a business because they're my heroes, those small business owners and entrepreneurs.
That wraps up this episode of the Small Business Contracts Coach. A clear operating agreement can prevent costly disputes and protect both the business and its owners. If you're a Texas business owner and want your agreement reviewed or drafted, visit fixedfeelawfirm.com. Don't forget to like, subscribe to the show, and leave a review if you found this episode helpful. We'll see you next time.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.